There we go. We're recording.
Hello, I'm Randy Week of the Teachers Retirement Legal Fund, TRELF, and I'm with our attorney today, Mr. Theodore Lavit, and he is here to explain the merits of our case that we are considering filing against the state legislature, the governor, and others concerning the Kentucky teacher retirement system shortfall in funding, and the merits of this case today. Mr. Lavit was a key litigant in the 1989 Rose versus Council case, and I will turn it over to him at this point to explain the merits of our case. And I'll start it off by saying that there are some who are concerned that teachers and retired teachers have no standing currently as regards the underfunding of the retirement system.
Thank you, Mr. Week. I've been asked to reply to questions of that nature, and I want to first start out by saying that teachers are the recipients eventually of their retirement, and they are paying money from their salary, and each paycheck there's a deduction of 11% plus from their salary for retirement benefits. At some point in time when they retire, after 25 years or so, they have an expectancy to receive retirement benefits. And we know that their contract with the state is formulated or is based on a contract that exists by statute. And I'll talk to you about that in just a moment. We know that that statute protects them. We know that that statute was passed by the legislature of Kentucky. We know that that statute cannot impair their right to these retirement benefits. And we know that their right to these benefits cannot be impaired. A law which impairs the obligation of a contract is one which renders the contract in itself less valuable or less enforceable, whether by changing its terms and stipulations, its legal qualities and conditions, or by regulating the remedy for its enforcement. Stated another way, to impair the obligation of a contract is to weaken it, lessen its value, or make it worse in any respect or in any degree. Now, I told you that teachers are protected by contract. There is a contract with the state of Kentucky. The legislature, in enacting Kentucky Revised Statute, or KRS 161.714, is entitled Inviolable Contract. It's hereby declared that in consideration of the contributions by members and in further consideration of the benefits received by the state from the members' employment, talking about teachers, the statutes pertaining to retirement for the teachers shall constitute an inviolable contract of the Commonwealth, and the benefits provided herein shall not be subject to reduction or impairment by alteration, amendment, or repeal. That statute is backed up by another statute, KRS 161.420, which discusses and is entitled Funds of the Retirement System. And here's what that statute says. All of the assets of the retirement system are for the exclusive purpose of providing benefits to members and annuitants, and defraying reasonable expenses of administering the system. The Board of Trustees shall be the trustee of all funds of the system and shall have full power and responsibility for administering the funds. But here's the catch. It is hereby declared that the restrictions and rights provided herein shall not be subject to reduction or impairment by alteration, amendment, or repeal. All of the assets of the retirement system shall be credited according to the purposes for which they are held. Now, we know that these laws regarding the impairment of the right to contract have a beginning. And in the United States, they begin with Article 1, Section 10 of the United States Constitution, which was ratified by Congress and became the law of the land in 1791. Article 1, Section 10 provides that no state shall pass any law impairing the obligation of contract. No state shall do that. And remember, the state of Kentucky has passed a law setting up a contractual relationship between the Commonwealth of Kentucky and the teachers of the state of Kentucky. All of these teachers being employees of the state of Kentucky. After that constitutional provision, the Kentucky Constitution provides in Section 19, no ex post facto law, nor any law impairing the obligation of contracts shall be enacted. We know that there are numerous cases that have gone to the United States Supreme Court, and the United States Supreme Court has upheld Article 1, Section 10, the same as being upheld by the Commonwealth of Kentucky in numerous lawsuits involving the impairment of the right to contract under Section 19 of Kentucky's Constitution. You have to go no further than read the famous case of Indiana XRL Anderson versus Brand, decided in 1938 by the Supreme Court of the United States, which held that one legislature cannot impair the right of contract that was given to the teachers by a previous legislature. Now, I can answer any questions, or try to answer any questions that you propound to me. One of the questions that's been asked is, well, do these teachers have to suffer a present loss? Absolutely not. We know that their contract has been impaired. You don't have to wait until the bottle is broken before you start throwing rocks at it. We know that the contract has already been broken. The impairment of the contract exists today. In 2013, we know that actuarially the retirement system was only 51.9% funded. We're a year down the road now, and we're below 50% funding. In other words, the new teachers that are coming into the system right now are paying for those that are just getting out, just retiring. But can they ever expect to receive their retirement benefits? The answer is they cannot under present funding and under present actuarial forecasts. Actuarially, we have to look down the road 30 years. And we know that we're less than 1/2 of the way being funded. So these teachers who are coming on board now, who are just there for the first few years of their entire teaching life, will never be paid under present funding scheme. Teachers that are just getting out may not be funded for their lifetime. We know the teachers are in a special category. They do not pay Social Security here in Kentucky. And this leaves them in an extremely precarious position, because will they have anything to retire on? They won't have Social Security if this system is busted, and they won't have retirement benefits. There's no question that actuarially we can prove right now that the system is impaired, and the contract that the Commonwealth has made through the legislature has been breached. So we do not have to have present damages to any teacher. Yes, they'll be funded, and we can see that there may be funding for the next 3, 4, 5 years, but certainly not fully funded beyond that at the present rate of our investments. I'll be happy to answer any questions. I think it's been proposed that this will be a suit that takes many, many years. Well, that's not true. A lawsuit certainly is an expensive task, but it's not going to take 10 years or even 5 years to get this case through the courts. A lawsuit of this kind has to emanate in the Franklin Circuit Court, and from there it is of such importance that it will go straight to the Supreme Court of Kentucky, in my opinion, just like Rose versus Council did. It will skip the Kentucky Court of Appeals and go straight to the highest court in Kentucky. There are federal ramifications even after the Supreme Court of Kentucky. The case has the ability to go to the Supreme Court of the United States because of its violation of Article 1, Section 10. I'll be happy to answer any questions posed to me during this interview, but I wanted to give you an outline of where legally I believe the teachers of Kentucky stand with respect to receiving their benefits.